This fifth webinar is going to focus on employment law, all of the things that happen with COVID-19 during and post-COVID. We have our national president, Dr. Charmaine Emelife, who's going to talk to us about the organization, and then we'll go into our presenters.
So you ready for me?
Yes.
Okay, thanks everyone and welcome to yet another exciting and interesting, potentially very educative webinar for the organization. Thank you presenters for making out the time to be here, and our members for making out the time to listen in. As you know, the Association of Nigerian Physicians in Americas represents the interests of over 4,000 physicians in the country, including the Caribbean. And we are working very hard and effectively to improve our vision of a healthy Nigeria in a healthier world. And as you do know, there's a lot happening in the world right now, COVID-19 pandemic being one of it. So we have to keep bringing to you your focus and forefront all the different things that's pertinent to you and how you can avail yourself of the laws surrounding it in this country. Let me quickly remind you about the benefits of ANPA membership, and one of it being this ability to listen to the experts and learn from them and apply it to what you are doing in your everyday life. Of course, your professional developments, which we take care of in your CMEs, and collaborations, information sharing, one of the other membership benefits that you have available to you. Being a leader like me, Dr. Coral, and all the members of the board, and you, the chapter chairs, and you know it, it's always a good way to get the training to be able to excel wherever you are in this world with this basic learning you would hear from us. Practice referrals, networking, and support. Support at times like this with the COVID-19, whether it's with your family, your friends, whether you're having a baby, like one of our doctors just had. It can beat that when you have this big family to work with. And of course, we provide you the ability to go back to your country, to give back as a volunteer, participate in global health and medical missions, and more to come. So thanks so much for being here today as we move forward to helping you navigate the COVID-19 and what it means for you and the employment of your staff. Thank you. I yield back to Dr. Cook.
Thank you very much, Dr. Charmaine. Today we invited two employment attorneys. One is in Georgia, it's Jay Rollins, and the other one is from Miami, Florida, Nnamdi Jackson. They were part of our webinar number 3, I believe, or number 2. Very, very engaging conversations, and by popular demand, they were requested to come back again. So we're going to hear from them today. Some of the topics that we'll be discussing includes, as you can see on your screen, things like, are you required to pay an employee who refuses to work because they're afraid of being exposed to coronavirus? And if you can make employment changes, and can you file in unemployment benefits if you reduce your hours and wages? All of those things they're going to discuss. Just to remind everybody, our experts are giving ideas, not advice. So the opinion serves as an educational purpose only and provides general information and basic understanding of the applicable law. So this should not be construed as a legal advice. Without further ado, I'm going to, I was going to have Jay go first, but I haven't heard him. Jay, are you on the line? So Nnamdi, I'm probably going to have you go first then, okay? Nnamdi, can you hear me?
Yes, sir. I can hear you.
Okay, wonderful. So you're gonna go first, and then whenever Jake joins us, he can he maybe having some technical issues.
Okay.
All right. And Nnamdi, please introduce yourself to our membership and tell us just a little bit about yourself, where you are. I know you didn't get to do that last time. We kind of want to know also a little bit about your background. Where's the name Nnamdi from, you know?
All right, well, I'm Nnamdi Jackson. My first name, Nnamdi, is a Nigerian first name, meaning firstborn. Some parts of Nigeria also say it stands for, I believe, my grandfather lives. I practice employment law in South Florida. I'm licensed here only, and my main part of my practice, 99% of my cases are in employment law.
Okay.
Now, thank you very much for inviting me again to be here, because we are in a very unique time with COVID and a lot of moving parts, and that's why the Department of Labor and OSHA and the CDC and the EEOC, all these governmental agencies are trying to release as quickly as they can different type of guidance, because they know that this is not something that's been handled by the courts over the past 20 years, 30 years, 40 years. This is all really very, very new. So one of the things I wanted to talk about today is the ADA, so the Americans with Disabilities Act. So the Americans with Disabilities Act mainly has two parts. Number one is the protection from discrimination. So Title I of the ADA deals with you can't discriminate against someone with a disability regarding hiring, firing, advancement, compensation, and so forth. And the ADA is confined to employers that have 15 or more employees. Now, with COVID-19, the EEOC, which is the Equal Employment Opportunity Commission, they actually have not said that COVID-19 is a disability, but the ADA still applies to employers that have employees of 15 or more. So arguments can definitely be made if it's a disability or not, because underneath the ADA, a disability is defined as a physical or mental impairment that substantially limits one or more major life activities. And activities are things such as walking, talking, sleeping, taking care of oneself. But the EEOC hasn't directly said just yet if COVID-19, if contracting it would qualify. And I mentioned that specifically for employees and employers because when someone has a disability, then parts of the ADA will apply where reasonable accommodation can be requested by the employee. If the employee has a disability, they can go to their employer and say, I need an accommodation to perform my job. But again, the EEOC hasn't specifically said if COVID-19 is a disability just yet. And if you could go on to the next slide, please. On slide 3. All right, so the next major part of the ADA is the portion that talks about the confidential information that the employer has about its employees. All right, so the interplay between the ADA and the confidentiality is primarily in Title I of the ADA, and the ADA basically requires employers to keep confidential the medical information of applicants and employees. And it's always important to mention that applicants apply as well. So confidentially hold on to information about the medical information about applicants and employees. Now, during this pandemic, the ADA covered ADA covered employers, which again are ones that have 15 or more employees. Employers are allowed to ask their employees if they're experiencing symptoms of COVID-19. So the symptoms includes things such as fever, chills, coughs, shortness of breath, and a sore throat. And again, the employer must maintain all of that information as confidential. As public health authorities and doctors learn more about COVID-19, they may expand the list of symptoms that apply. Now, one question that comes up a lot is, what if employees have symptoms of COVID-19? The CDC itself has stated that employees who become ill with symptoms of COVID-19 should leave the workplace. The ADA does not interfere with employers following that advice. Okay, because the interplay again between the CDC and the recommendations that they're giving out, usually the CDC, the way they see it, will control. And at least so far from what I've seen, I don't see any conflict between what the CDC has recommended and what the ADA requires. And now in slide 6, confidentiality. Medical records are confidential. The basic rules have a limited exceptions. But one of the things that is also going to be confidential is information where you're talking about the diagnosis. So even if there's no diagnosis or there is one, that is confidential information that the employer needs to hold onto. So if the person just feels like they're sick, haven't particularly been diagnosed with anything, the employer can't just go spread that information specifically about that employee.
Let me know if you want me to advance to the next slide.
Okay. Now checking an employee's body temperature. Again, this is a rather common way to try and see if someone has COVID-19. So the CDC and state and local authorities have acknowledged that the community spread of COVID-19 and issued attendant precautions as of last month. So underneath what the CDC has instructed, employers may measure the body temperature of the employees and keep that information confidential as well. If we move on to the next slide. So the CDC states that if an employee is confirmed to have COVID-19 infection, employers should inform fellow employees of their possible exposure to COVID-19 within the workplace. Because again, that's a question that comes up a lot. Can I tell people that have been exposed that they probably should go get a test done? That's definitely within the right of the employer. Just do not mention which particular employee and the confidential information beyond that point. It can just be limited to, I believe you've been exposed based on information that I have. I suggest that you get a test done. And then the link that I have on this particular slide, on slide 8, to the cdc.gov, it provides extra information as far as how employers can deal with that issue of exposure within the workplace. Now, regarding being short-staffed, during these times of being furloughs and layoffs, sometimes employers are going to be deciding to have an employee take on even more tasks than what they had before. So that's a question that's come up quite a bit. So absent a contract that says otherwise and absent some type of discriminatory intent, then the employer is going to be free to go ahead and change the job duties and job tasks of his or her own employee. In most states, especially here in Florida, absent a contract, an employee is presumed to be hired at will. So employment at will means an employee can be terminated at any time without any reason or warning. And also the flip side of that is that the employee can quit at any time as well, right? So just be wary about any type of perceived retaliation when job tasks are actually changed. So for example, if an employee is an accountant and that accountant employee reports a manager of the human resources for some type of discriminatory comment that the manager made, well, it could look retaliatory if the next day the job tasks are changed, right? So just be wary of that. But during these times, that's a common thing that's going on of employees having to take on extra job tasks because certain employees have been let go. And some employers are allowing those leftover employees to pick up the extra slack. And then on the family, on the next slide there, Family Medical Leave Act. One thing that's caused some confusion is that these amendments to the FMLA they apply to employers have 500 or less employees. These expansions of the FMLA that have been amended so that there's paid leave. One of the requirements that the employer have 500 or less employees. Well, some people have thought that that meant that the original FMLA requirements have been done away with, and that is not the case. So the FMLA, as you've known it in the past, where if an employer, where an employee has worked for an employer for at least 12 months, has worked at least 1,250 hours in the previous 12 months, and at that particular location has at least 50 employees or employees 50 or more employees within a 75-mile radius, that person would, if they meet all those requirements, would still qualify for unpaid leave underneath the original form of the FMLA. The amendments, you know, kind of act as their own as applying to employers that have 500 or less employees. And again, all those things you spoke about the last time that I was here regarding, you know, what qualifications the employer and employee need to meet for that employee to get paid leave. But those unpaid leave requirements underneath the original FMLA, they still apply. That has not gone away. And so on the very last slide, there are some resources for everybody of different links to the DOL, the Department of Labor website, and to the CDC and to OSHA, because pretty much every week more questions are being answered and more guidance is being given from the administration as things move forward. So thank you for your time.
Okay, thank you, Nnamdi. Stand by. We're gonna let Jay go, and then you two of you can tackle all of the questions at the end. Is that okay?
Sure.
Okay. All right. Jay, you may be muted, so I may have to unmute you. I know you probably you can hear me, but we can't hear you yet. Are you able to unmute yourself, or I have to unmute you? Okay, let me see if we'll find you. Jay is an employment attorney here in Georgia. 770, I think I see you. Okay. All right, you're on mute now. Jay, can you say something?
Yeah, I just heard that I was unmuted. Can you hear me now, Doctor?
Yes, we can hear you very well. So just tell me, right now you're on the first title slide with your handsome picture on it.
Yeah, so you can go to the next slide. And Mr. Jackson, feel free to jump in. You know, I'm approaching this with just the questions that Dr. Okoro sent. So I'm just going to go through the questions and my answers. And Mr. Jackson, if you have anything that you can add, you feel free to jump right in. But Dr. Okoro, first of all, I want to say thank you. Thank you for having me again, and I appreciate the opportunity. And I hope that that it can enlighten you a little bit. I know it's a hard time, and understanding all of the information that is coming out on an almost daily basis it's tough to digest. And so we're going to try and boil that down and answer your questions to the best of our ability. So the first question that Dr. Okoro sent was, how should you handle at-risk employees? Those employees who are pregnant, who are over 60, who have other health conditions, etc. So I will start by saying every one of you should probably go to the EEOC's website and download their Pandemic Preparedness in the Workplace document. Also, the CDC has interim guidance for critical workers implementing safety practices. And it also just recently issued a reopening businesses with workers at risk for serious illness. These are going to have some great guidelines for you, and I know our time is somewhat limited, so I'm going to send you to those sources, but the EEOC's Pandemic Preparedness in the Workplace is a great source of information, and it was just recently updated to specifically respond to questions that have come up with regard to COVID-19. With concerning these at-risk employees, everyone should consider what accommodations, what reasonable accommodations that you could offer to protect these individuals, at least on a temporary basis. And to a great degree, we all know that there are some low-cost solutions that you can offer with materials that you probably already have on hand or that are easily obtained. Things such as restructuring temporary job restructuring of marginal duties, temporary transfers to different positions, modifying a work schedule or a shift assignment may also help permit an at-risk employee to perform safely their job duties. Some other things that the EEOC suggests are designating one-way aisles, using plexiglass tables or other barriers to ensure minimum distances between patients and coworkers. So you can be creative to the extent that you can work with the employees to make sure you can reasonably accommodate their at-risk status. Go to the next slide, Doctor. Are you required to pay an employee who refuses to work because they are afraid of being exposed to the virus? I think Mr. Jackson touched on this, but the answer is no. There is no law that requires that an employer pay an employee who refuses to work. However, you should take proactive steps to make sure that everyone's following the CDC guidelines and also to protect these at-risk employees that we've discussed. There is one caveat to that. On Section 13A of OSHA, employees are entitled to refuse to work if they believe they are in imminent danger. The Act defines imminent danger to include any conditions or practices in any place of employment which are such that a danger exists which can reasonably be expected to cause death or serious physical harm immediately. Most workplaces in the United States do not meet this element, the elements required for an imminent danger. Certainly in doctors' offices, you may run the risk periodically of having patients who are positive for COVID-19. So that you need to be careful of, and obviously pre-screening information from patients is something that can be very important. Next slide, Doctor. If an employee is sick with COVID-19 or think they are, when can they return to work? Employees should be directed to stay home until they are released from a medical provider. Under the current circumstances, sometimes getting a release from a medical provider can be difficult. If it is not an option to get a release from a medical provider, the employee should not return until both of the conditions that are listed there are met. One, the employee needs to be symptom-free for at least 3 days without fever, and that without fever be achieved without medication and has no respiratory issues. And it's been at least 7 days since the symptoms first appeared. Ultimately, the decision about to stop home isolation and return to work has to be made between you, the employee, and the medical provider. The EEOC's, I will mention it again, the EEOC's pandemic preparedness in the workplace has questioned a lot of Q&As, and it addresses some of these questions about sending someone home and what you can require when they return. Next slide, Doctor. Who from your medical practice can reasonably work from home? The answer to this question certainly depends very much on what type of practice you have and how you run your practice. An employee who actually has to observe or examine a patient or do testing on a patient certainly has to be in the office unless they can do it by a video examination through Zoom or some other technology. However, many of your staff can probably work from home at least on a part-time basis. Those nurses who take medical calls and set up appointments from patients, those who are responsible for calling in prescriptions to the pharmacy, can work from home. Your workers in the billing and insurance departments may be able to work from home, at least on a part-time or an intermittent schedule. And you may be able to as Mr. Jackson was addressing earlier, may be able to move some job duties around so that you can maximize those employees who can stay home and get and shift responsibility for duties that can be done at home to those employees. Next slide, Doctor. To make ends meet, can you decide to make an across-the-board pay cut? The answer is yes. You can make across-the-board pay cuts, but we advise that you review the financial needs of the workplace and make decisions that will be perceived as fair and reasonable by the workforce. For instance, you might decide that you are going to cut only those employees who are at a certain pay grade or higher, with the understanding that individuals at a higher pay grade can better sustain a cut in pay. Pay cuts, downsizing, and furloughs are difficult financial decisions that businesses have to undertake with much thought and deliberation. Of course, a pay cut can't take an employee below minimum wage, and if a business is receiving a Paycheck Protection Plan loan, you have to be really careful about pay deductions because they would also need to be addressed and reinstated in order for the loan to be forgiven. Next slide, Doug. Can an employee file for unemployment benefits if you reduce their hours? The easy answer to that is yes, but whether an employee with reduced hours can get benefits is based on the amount of their reduced wages and the state in which they draw benefits. In Georgia, which is where I practice, back in March, the Georgia Department of Labor announced new requirements for employers filing partial unemployment claims. And the Georgia Department of Labor has required all employers to file partial claims on behalf of their employees when it's necessary to reduce hours and there's not enough work available for this short period. Certain employees are excluded from that requirement, those that are laid off, those who are on a scheduled leave, 1099 employees, there's a short list there. And in Georgia, in order for an employee whose hours are reduced to be eligible for benefits, the employee can't make more than 416, I think it may be 415, and that's just a mistake, dollars on the reduced schedule. Thus, what I have been telling a number of some employers is, rather than reducing across the board your employees' hours, choose one or two, keep them on full time, and furlough other employees so that they will be eligible for unemployment benefits. Next slide, Doctor.
Okay, I'm done.
As was alluded to earlier, can you legally change an employee's duties due to being short-staffed? The answer is most definitely yes, unless, as Mr. Jackson mentioned earlier, there's a contract and there are specific duties in the contract that are not changeable. However, most contracts, employment contracts, do provide certain flexibility with regard to duties. If there is no contract, most states will, under certain our current circumstances, allow you as the employer to change any of the terms of employment that you wish, and then of course the employees can decide if they want to do it or not. It is important, however, to understand that you cannot single employees out in a manner that will be perceived as negative treatment or require them to do some of the more, certain employees to do the more demeaning tasks for a discriminatory purpose. And that brings up something that I think we started out with, and that is that all of the, it's easy to forget that right now we're in the middle of a pandemic, but that doesn't change that the laws, the federal laws with regard to discrimination, with regard to wage and hour, they all still apply. So you still have to keep in mind that you can't treat different employees differently or in a way that might be perceived as discriminatory or retaliatory. Next slide, Doctor. How do you handle employee benefits while they are on furlough or leave? Employee benefits are first and foremost always going to be dictated by your plan, your benefit plan documents, or your policy language. However, for example, during the pandemic, most health insurers have waived the minimum hours requirement for furloughed employees to remain on health insurance. Therefore, those employees do not have a qualifying event and aren't required to go on COBRA. At the end of the day, it's still your decision, but you can continue furloughed employees on your health insurance with the same contribution ratio between the employer contribution and employee contribution. Ultimately, your plan and policy language will control. Make sure to clearly understand the differences between employees on leave, on furlough, employees that are laid off, or who are permanently terminated. Most importantly, however you handle benefits, again, make sure that you treat similarly situated employees the same and avoid the appearance of discrimination or retaliation. Next slide. What compensation are employees eligible for under the CARES Act? As most of us know, on March 27th, Congress passed and the President signed the CARES Act, which is a $2 trillion stimulus package, which included, as we've all heard, the Paycheck Protection Plan. It also included an unemployment supplement plan, and it included direct payments to employees. The Paycheck Protection Plan focuses on sustaining small and medium-sized businesses. It offers loans to small employers, and I'm sure we have all heard the news about who's been getting it and who hasn't been getting it. And unfortunately, the money ran out on the first go-round within a matter of days. Round 2 is now underway. So if you haven't already, if you would like to apply for a Paycheck Protection Plan loan, and if you haven't already gotten your information in, get it in as quickly as possible. The bill also expands unemployment benefits in a number of substantial ways. First, in addition to whatever an employee, either a partially unemployed employee or an unemployed, furloughed employee is entitled to under state law, the CARES Act adds an additional $600 per week from the federal government on top of whatever the state benefits are, and adds an extra 13 weeks of payment that is allowed beyond what when the state's benefits end. The bill also extends the unemployment assistance program to independent contractors, self-employed individuals, gig workers who are normally not eligible for unemployment benefits. The Act also provides for direct payments to employees depending on how much they make. Most employees, single adults who have an adjusted gross income of $75,000 or less would get the full $1,200. Married couples with no children earning $150,000 or less receive $2,400. Taxpayers filing as head of household would get a full payment if they earn $112,500 or less. And for every child under 16, the payment would be an additional $500. As the news reported last week, of course, many checks went out. I'm not sure if all of them have gone out, but no, I take that back. I know all of them haven't gone out, but the checks have started going out on the direct pay. Next question. Next slide, Doctor. How much extended time off are you responsible for due to COVID-19 related illness or circumstances? We touched on this, I believe, in the last seminar. And what's most important is the very top of that slide. These leave provisions only apply if you have work for the employee to perform and he or she cannot perform that work for qualified reasons. Therefore, if as a number of specialty practices that I represent ran into, they essentially stopped doing anything but emergency or follow-up care. So for patients. So they didn't have a full schedule for employees to work. So an employee's eligibility for leave under the FFCRA is limited to what they would be entitled to if they could work. There are 6 qualifying reasons listed there. And that the employee is subject to federal, state, or local quarantine, that they've been advised by a healthcare provider to self-quarantine, that they're experiencing symptoms and are seeking medical diagnosis. If an employee needs to take leave because of one of those 3 reasons, he or she is entitled to 2 weeks or up to 80 hours of paid leave at 100% of their pay, up to $511 per day. If the employee needs to take leave because of categories 4 or 6, which is caring for an individual that is subject to a self-quarantine or a quarantine issued by a doctor, or is experiencing other substantially similar conditions, they are entitled to up to 2 weeks or 80 hours of paid leave at 2/3 of their pay, or a maximum of $200 a day. Reason 5 has seemingly been the trickiest, and it's because, of course, it affects more people. If someone needs to take leave in order to care for his or her child because their child's school or daycare is closed, then they are entitled to up to 12 weeks of leave paid at 2/3 of their pay, and that is job protected leave. However, it is important to know that it's a tricky thing because you can also you can require proof of closure. You can require inquire as to an employee's ability to share child care duties, or the employee's need to be the primary and only child caregiver. The understanding that this is a very tricky category, the DOL has issued guidance basically saying this category, they recommend that employers and employees work together to work out an intermittent leave schedule or a work from home schedule. It is specifically recognized that the use of intermittent leave in these situations is encouraged, and that employers and employees should work together to figure out a way to make this work on an intermittent basis if possible. All right, next slide, Doctor. Is your practice exempt from FFCRA's expanded medical leave provisions? The answer to that is no. Under the FFCRA, there are special rules for healthcare providers and emergency responders. And employers of healthcare providers and emergency responders may elect to exclude some employees, such employees, from eligibility for leave. The exemption for healthcare providers only relates to people considered healthcare providers, as that term is defined. Doctors, nurse practitioners, and midwives are considered healthcare providers under the FFCRA. Nurses, administrators, and support staff are not considered healthcare providers under the definition as used in the FFCRA. So they would not be excluded, and therefore they would be entitled to the expanded leave. Now, on the other hand, the DOL, and this is where we get into confusing and trying to make sure you understand what everyone is saying. The Department of Labor defines healthcare providers more broadly for other purposes. However, it's the FFCRA that specifically defines healthcare providers as doctors, nurse practitioners, and midwives. Next slide, Doctor. Are employees essential or non-essential under state guidelines? Healthcare providers and medical practices are considered critical infrastructure organizations or essential businesses under most of the shelter-in-place and stay-at-home orders, and therefore employees can be considered essential, but only if they are performing essential functions. So most shelter-in-place orders also say that if there are duties that can be performed remotely, then that's what the employers should be doing with their employees. For example, as we mentioned earlier, billing and insurance people who can access your records from remotely and can do their job at least in part remotely should still be allowed to do their jobs in that manner. Georgia's governor this past week issued 2 orders loosening the shelter-in-place order, and I wanted to address that here because I think it is important as we go forward and other states begin to loosen up the shelter-in-place orders. The governor's order encouraged medical practices to begin reopening for appointment and performing elective procedures. On the other hand, the governor's order it's really important to get a copy of it and read through it, because the governor's order also lays out lots and lots of specifications with regard to any number of industries, and specifically talks about healthcare providers. There are lists of, in one category, up to like 39 or 40 different things that the order says that employers should do before reopening or beginning to offer services to the public again. I encourage you to familiarize yourself with these directions. Next slide, Doctor. What precautions can you take to keep employees safe at work? The CDC, and I mentioned this early on, the CDC's guidance for critical worker implementing safety practices is really useful. Familiarizing yourself with the EEOC's pandemic work handbook is very instructive. In this particular, as I just mentioned, the governor's order in Georgia has a very specific list, but some of the things that you can find that the CDC has recommended are on the slide. Pre-screening of employees with doctor's offices. I would probably suggest considering pre-screening of patients, keeping anyone with symptoms out of the workplace. And as I'm sure you all saw, the CDC added an additional 6 symptoms to the COVID-19 list this past weekend. Promote healthy hygiene practices, use PPEs, intensify cleaning and disinfection. If you don't have an outside service coming in, I would suggest considering having an outside service coming in on a more regular basis. Controlling your groups and number of patients and or employees at the office or in a particular spot at one time, especially in the waiting room. Canceling non-essential traveling. I don't know that it's an issue for you guys. Spacing out seating and making sure that you stagger patient visits. Restricting the use of any shared items in spaces. Some of the other things I mentioned earlier is establishing traffic lanes, one-way lanes, so that to minimize the amount of activity in one particular area, and make sure you train your staff about in all of the safety actions. Next slide. What financial relief options do you have to supplement your decreased revenue? As we mentioned, the CARES Act provided the first round of Paycheck Protection Plan loans, which money was used up pretty quickly. We are now in the second phase of that. That is certainly an option. Both the CARES Act and the FFCRA contain tax exemptions and tax credits that are available to employers. Your accountant should be able to help you understand those a little bit better than I can. The SBA also provides other disaster relief loans. And talking about the Paycheck Protection Plan, I think it's really important because there seemed to be a lot of, maybe not fraud, but money going maybe to some businesses that traditionally wouldn't be considered a small business. The Treasury Department came out on Thursday with some frequently asked questions and strongly urged businesses or required businesses to assess their economic need for a loan before submitting an application. And further advised that if even when people who get the money, but then they don't have the cash flow issues, they have a window of correction to pay back the money without any legal consequences. Next slide. How can you assist your staff with salary compensation when you're faced with revenue loss? Obviously, the PPP loan that we've discussed, and if you have can get that, it's a great thing. I think we talked in our previous webinar about more specifics with regard to what the limitations are and what you're entitled to request. Retain essential employees and allow them to work from home, staggered schedules. Try to work with your staff to make sure that you can assist them as much as possible and the balance of full-time employment, partial employment, and being able to get unemployment. Furloughing employees is also another option, and because it's tricky with partial unemployment, as I mentioned earlier, what I've been suggesting is choose one or two of your employees to keep on full-time and allow the others in that category to furlough and go on to unemployment. If they're eligible for unemployment benefits, then they're also automatically eligible for the $600 supplement under the CARES Act. The recent legislation also greatly relaxes the penalties for taking money out of a 401k plan or a retirement plan, and other options are providing assistance, develop a voluntary relief and compassion fund, or provide employees with a list of community resources for debt counseling. And you can also contact insurance providers to inquire about subsidizing benefits. And I know it's tough, but you can also provide information to employees about how they could take loans from their retirement plan rather than actually removing money from their plan. Next slide, Doctor. How can you properly staff your practice in the midst of COVID-19? A lot of this is now beginning to get cumulative. Stagger, plan, establish a schedule that minimizes potential exposure. Map out your needs, map out your office and how you can best practice social distancing as much as possible in the workplace. Obviously, instituting protective measures. Provide as much PPE as you can. Rearrange work areas, control patients, and schedule. Next slide, Doctor. What do you do with contract employees during this time of uncertainty? First of all, if they are direct contract employees, as contract employees under the CARES Act, they would be entitled to apply for and receive the federal supplement for unemployment. Another option is to utilize them maybe over even payroll employees, because payroll employees you can furlough, allow them to get unemployment and the supplement, and they can also stay on your employee health plans. It's important just to sort of analyze and map out how are you going to maximize what you need and also to try and help yourself as well as your employees. The contractor is engaged through a third party, and you work with the third party to maximize the contractor situation. And that's it. Doctor, any questions?
Awesome, Jay. Thank you very much, Jay and Nnamdi, for a comprehensive overview of employment law. We have a lot of questions, people texting, and by the way, if you have questions, you can unmute yourself and ask the question. Otherwise, you can also type the question, your question on the chat. The first question on the chat says, can you ask what to do? Okay, asking me, what can you do with the PPP program when your your unemployment pays more than the staff salary, and they want to collect it before returning to work?
Stanley, this is Charmaine. Can I just butt in for 1 second before
Yes.
they answer the question?
Yes, go ahead, Charmaine.
Yeah. So thank you so much. I just wanted to thank Mr. Rollins and Mr. Jackson, and specifically really thank Attorney Owabe Zibele, who introduced Mr. Jackson to us and brought us second time, and Mr. Jackson is coming here second time. I think Mr. Zibele is also on, and you've been a good sponsor for our ANPA local and national events. So we just wanted to make sure we acknowledge it, and thank you for giving us this link with Mr. Jackson that's also presented here. So with that, I yield back. Thank you.
Thank you, Madam President. So either Jay or Jackson. So I guess the question is, some employees are making more money with this unemployment benefit than they are getting from their regular job. How do you address that?
Well, I will jump in. I mean, I understand the question. On the other hand, if you get the PPP money, you have to spend at least 75% of it on payroll. And ultimately, unfortunately, I get that when the Congress was debating the CARES Act, that was one of the concerns, is we're making it more lucrative for employees to be on unemployment. If you decide to put your employees back on payroll, that's your choice, and they aren't entitled to the unemployment. I know it's a hard decision, but if you get the money, and you're going to get the money, you have 8 weeks to spend it, and 75% of it has to be spent on payroll. And then you also, for it to be forgiven, you have to have the correct number of employees on payroll during that 8 weeks, as compared to two other time periods. So, for the good of the business, I think that you just kind of have to. Employees have to take that one on the chin.
Can I ask a question?
Go ahead. Please state your name and what chapter you are from, and then ask the question.
I'm Cordelia Udo. I'm from Delaware, Pennsylvania chapter. For a practice that's been my practice, middle of March, I decided to fold and to restart on May 4th. And of course, these people enjoying the unemployment, as you stated. And so one decided to challenge me that in Pennsylvania, the governor said businesses will reopen on May 9th or May 8th. That will mean that she will not come in on May 4th. Initially, she gave excuses. She's taking care of her mother, and wouldn't want to be exposed. Then I gave her the option of staying in my second office on the days that she works, because she does the billing, not the billing, but the collection. And she will be the only one in that office. And so the second excuse was, can we really, am I sure I'm not going against the law? So that's number one. And of course, I came back to her and said, no, we're still considered essential workers. I've been treating people over the phone, and some of them have gone to the emergency room, and I've gotten a report, and that I don't believe that my practice is included in that order. So I don't know if I'm really correct or not. And the second question, if the CARES Act, well, for those who did not get it, are we sure we're going to all get this?
We all wish we were all getting them.
Because I have not, if the application I put in last night, I'm not sure if that will get to somebody. Nobody has responded. So if we're sure we're really gonna get this, then I don't know how we can modify what we do if we know we can get it, and what to do if we get it. So that would be, I mean, I'll ask, I like to get what your advice is on this too.
So, I mean, with that first question you had regarding, you decided to close your business. So in Pennsylvania, was your business considered an essential business that could have stayed open if it wanted to?
Yes, that's ophthalmology. I mean, the only thing I know that we put on hold until maybe June or July are surgeries, elective surgeries. But some people do get injections. Some people have even coronavirus affects the eye, causes conjunctivitis. And so and can actually cause more problem behind the eye, inflammatory, reactions. Not that I'm looking forward to going to diagnose coronavirus looking in the eye, but yes, we are considered essential workers.
Okay, so if the Pennsylvania's governor had issued some type of order, because I haven't read it, but if the Pennsylvania government had issued an order that would allow your business to stay open, then him reopening on May 5th or 6th, whenever it is, for businesses that were closed underneath his order, I don't see how your employee can then say that I'm going to come in when the order is lifted, as if your business was closed because of the order. It sounds like to me the order had nothing to do with it. You just voluntarily chose to close the business.
Voluntarily. Yes, absolutely.
Okay. I mean, that's up to you how you want to handle that as an employer. It sounded like the employee just wants to stay home for another, 2 days?
Yeah, they're getting a lot from this unemployment.
So,
and this goes with what the EEOC and other Department of Labor is saying, that, encouraging employers and employees to try and work together so that everyone remains employed and continues to just move forward when this is all over. But that's the most that they can really do, is encourage that. If an employee decides to simply not come into work when business is open, and they don't qualify for any of those 6 reasons that Mr. Rollins had just mentioned, then they're probably not going to qualify for FMLA. If they don't qualify for the FFCRA, if they don't qualify for any of these new things that have been added, and they're just simply not coming in, and they're healthy, no kids at home, no parents to take care of, no spouse to take care of, then
actually, I do have one that may qualify, but if I had you right, you said if the partner is also working, that they need to share the upkeep of the children. It will not just be one sharing. Is that, did I get you right when you went through that?
Oh, in the previous presentation, talking about if a parent is home?
Yes, if a parent is home due to the children or due to daycare not being open,
right?
It cannot just fall on one parent, because what one will do is the lower earner might not stay home. and allow the higher earner to continue. And so if I heard you correctly, that staying home should be shared between the two and not just one.
Ms. Rollins, do you want to jump in?
Yeah, you know, I don't. Here's the thing. I don't think you can require it. On the other hand, yes, you can inquire as to the ability of the employee to share childcare duties. You can also work on or require that they work an intermittent schedule if there is a second person that they can share duties with. And you know, I have been telling people that you can push the issue in terms of one person can't just decide. Well, certainly you can two parents can't say we both need to be home kind of thing. So you can inquire with regard to the sharing of childcare duties and work out an intermittent schedule at the very least that would allow your employee to work for you at least some of the time.
Okay.
All right, there's a lot of questions coming in. Just as a tag along to the previous question for Jay or Nnamdi, Mr. Jackson, if they refuse to come to work because they're making more money from the unemployment, what options does the employer have? Can you fire them, lay them off permanently? Can you suspend them? Can you write them up? What options do employers have when, you know, you as an essential business, you're open, but they have the fear or they give excuses, they have to take care of family members at home, but they don't really qualify under any of those other rules to be home and get be paid. The only main reason is they are getting more money from unemployment than they are getting from their regular paycheck. And also the second question is, if they're getting their regular paycheck, once you start paying them, then their unemployment should go down, correct?
Correct. I mean, and once you offer, I would recommend making telling the employee that you're bringing them back to work and that they are expected to report to work, do it in writing. And if the employee refuses to because they're voluntarily removing themselves from the workplace, yes, you then have the right to discipline them, write them up, even to terminate them. I would certainly then take your documentation and provide it to the Department of Labor and say, you know, they're not entitled to unemployment. I've offered them their job back.
Okay. There is another question about an employee went to work, got tested, they did a temperature test. It was like 104, 100.5, and she was asked to go home. And she later came back, said her private physician told her that she did not qualify for testing and should return to work. But the employer, what does the employer do when a patient, when an employee wants to come back to work, but their temperature is high? What right do the employer have?
It would be within their right to ask for a doctor's note when the employee returns. You know, this is a common thing with the ADA and the FMLA, where underneath both those laws, employers often will have forms for employees to fill out before they can get an accommodation or to get the leave. So regarding employees coming back, the EEOC has stated that an employer would be within the right to go ahead and ask for a doctor's note prior to the employee returning back to work.
Yeah, and plus, even if they can't get a doctor's note, there are some guidances that say that, I think we mentioned in one of the slides that there are two things that you can require that it happen. One is that the employee has been at least 3 days without a fever and not by taking medication, but without a fever and not experiencing any respiratory distress, plus that it has been at least 7 days since the onset of the symptom.
Another
Point
Question. This is Vincent Ogamu from Chicago chapter.
Go ahead.
Can you hear me?
Yes, we can hear you. Go ahead.
Okay. No, I'm not quite sure I got the answer correct from Jay regarding employee who collects more money during their unemployment, and employer, by receiving PPP money, must spend about 75% towards the salary. Now, what do we do? Now, if you recall them or you start paying them, what should be their salary? Would you still allow them to collect their unemployment? Because most of them know they are benefiting more from that collection. Suppose they don't come back, or do you recall them, start paying them their normal salary and still let them collect their unemployment? Jay, should I repeat my question?
No. I think I understand your question. It's just it's a tough situation. Yeah. If you offer them their job back, they should not be eligible to continue to collect unemployment.
Okay. But like you said, we must spend 75% of it towards the salary. Otherwise,
correct.
Right?
Correct. Okay. You have to spend at least 75 of the PPP money.
PPP money, right?
Right.
And depending on the state that you're in, the unemployment office might ask you as the employer, what was the reason why this person doesn't have a job? They might inquire as to what's going on, and you'll be within your right to tell them.
Only because of the lockdown. I mean, in Illinois, I'm a dentist, and I've been locked down almost 2 months. Well, my employees are collecting unemployment. If we resume, say, June 1st, hopefully, and they still are benefiting more from the unemployment, and you recall them back, they still are reluctant coming back, what do you do? Because I have received PPP money, which I must pay 75% off, and they're still at home. What should I do?
I said you document that you're advising them that they can come back for, at their wages and at the duties that they had prior.
Well, and two, part of the PPP money was in order to, even if you're still on a quarantine or a lockdown, if you pay them their regular pay, you also need to inform the your state Department of Labor, which would then make them ineligible for any unemployment. You pay them even if they're not working. You use the money during that 8-week period to maintain salary. That's what the PPP was intended for. Even if, that was the whole point. Even if you can't function on a full-time basis, the PPP money was intended for you to be able to cover your employee wages for at least 8 weeks. And you use the money to pay the wages, and you tell the State Department of Labor that you're paying this person and they're not entitled to receive unemployment.
Well, they're already receiving it. In other words, if I receive it, I'm anticipating, yes, I will get it. So as soon as I get it, I have to disburse them the salary. I have to pay them regardless of whether they are in or not, and they also have to discontinue the receipt of the unemployment. Or who terminates it?
Right, if they begin to get their compensation from you, they should not be able to then also apply for unemployment on the state. I mean, that would be fraud, and they would have to pay it back. And you can certainly jumpstart that by informing the State Department of Labor that you have received paycheck protection money and that you will be paying your employees, and therefore none of them are eligible for unemployment.
Okay. Can we recognize our president, Dr. Shaman? She raised her hand again. Shaman, you're muted. Okay.
And Doctor, I apologize. I'm probably going to have to hop off here pretty quick.
Okay. Hold on, Jay. There's one more question from Patrick Njoku. You raise your hand.
Conference. Is actually about the I guess a little bit of confusion about it. I have a small practice. I have about 3 people. They are all still working. And I understand from the presentation that you must spend up to 5% of that PPP. I have applied, I'm not received it yet. Looks like it's a narrow window, about 8 weeks to spend the money and spend up to 75% of the money. So assuming that one gets it, but don't spend up to 75% of that money, does it mean that one has to refund the whole money? And how does one keep record of that goes to salary, as you know, if one should get it?
Hello?
Just so that I'm clear, are you stating that you've applied for the PPP, your office is small and you're still operating at the moment, you've applied to the PPP loan, you haven't received it, and you're wondering about if you never receive it, if your income, what you have in your business account now, if 75% needs to go to payroll still, even if you don't get the loan. Is that what you're asking?
No, what I'm asking is if I do receive it and start using it to pay salary, how do I actually account for it? And if I don't spend up to 75% of the PPP for the 8-week period, does it mean I have to return everything in full, even if I have spent some, but not up to 75%?
I see. It's my understanding that, you know, if that 75%, let's say, is a few percentage points less, I don't believe it's a matter of returning the entire amount. It's just that the amount of what's forgiven of the loan gets reduced. Mr. Rollins, is that correct?
Yeah, that is correct. There is a formula for calculating how much of the loan can be forgiven, but forgiveness is a sliding scale. So you can be forgiven anywhere from 0 to 100%, depending on how you spend the money and depending on the number of employees that you have full time during the 8-week period, as compared to 2 other periods from January to February of this year or February to June of last year. And in addition, even if you furloughed some people and you still during that 8-week haven't gotten back up to full complement, there's still a window of correction that if you still get your workforce back up to full complement by June 30th, you won't be penalized. So it's a sliding scale. No, you don't have to return the entire amount. And if for some reason some portion of it is not forgiven, it would then convert to a loan, and right now the interest rate on that loan is 1%.
And as far as keeping track of, you know, if you do get the loan, you know, that's probably a better conversation to have with your accountant, but I have spoken to a few employers that have, you know, multiple accounts, and what they've done is just cleared out one account if they can, and what they did is they just ended up putting the PPP loan directly into that account, so that it's very straightforward that this is the money going towards payroll and to keep the lights on. But if you're not in a position to do so, you know, that's probably best where your accountant comes into play.
Yeah, I agree.
Can I chime in again, Dr. Odo, Cordelia Odo? I don't know if any one of you. So will there be a 3rd and 4th round of that PPP so that everyone will get it? It's so unfair for some people to get and not the others. Do we know that? And if others don't get, can we all file lawsuit, class action, and get ours?
Well, that last part of the conversation for another day, but I agree with you. I share your frustration on that. I've had the same problem as well as a number of my clients. But my understanding is that there is a plan for a third round of money, because we all know probably by the end of this week the second round will be gone. So we can only hope.
Okay, if there are no other questions, is there any other questions before our experts have to leave? If I didn't get your questions, please raise your hand. We're gonna end in about 2 minutes. The last question I have, is there a specific period during which the PPP money has to be spent? I believe that's the first 8 weeks after you receive the money, correct?
That is correct.
All right. Jay Rollins, ANPA, is Dr. Emily still online? I will have the president or the president-elect close us out. That will be the right thing to do. Dr. Emily, are you still on? Or Dr. Kunseri?
Yeah, Stanley, thank you very much. Can you hear me? So on behalf of the executive, I want to say a big thank you to all the presenters. You guys have been really very, very helpful to our members, especially with the number of questions you've had to answer. It demonstrates that, you know, we're all still very much curious about what to do post COVID-19. So again, we are grateful for your support, and we will continue to, you know, reach out to our presenters if we have further questions privately. So once more, thank you, and we look forward to future collaboration and partnership with the different presenters at this point. Thank you very much, Stanley.
Thank you, Chris.
Thank you.
I'm sure you guys noticed somebody tried to hack our webinar. We try to make it easy for our members to log in, but the next webinars we will have to institute a password and a waiting room to let people in. So this will not happen again. I apologize for that. But if our members want to make it easy for them to log in, but somebody trying to hack it from me, but I have to fight them off. Otherwise, thank you, everybody. Dr. Emily, are you still there? Can you raise your hand? Closing comments? Okay. All right.
All right. Thanks, Stanley. This is Diana. It was a very nasty hack, but I'm glad you were able to kick them off.
Oh yeah, I had to try to take over, but they can't do that. We're a little bit advanced than what they could do. I'm going to try to delete that part. This webinar is recorded, so during the upload, we're going to delete that part. Okay.
Thank you very much, and thanks. Good job.
Okay. Thank you.
Thank you, Jay Rollins. Thank you.
Thank you, guys. Thank you, Doctor.
Nnamdi Jackson.
Thank you, Mr. Jackson.
Thanks a lot, Mr. Rollins, and everybody else for having us.
Thank you.
Thank you. Absolutely. Absolutely. Take care.
Bye-bye.
Whew.